You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 95, Trademark Likelihood of Confusion Factors. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com, or call me at 424-281-0162. I had a few episodes already about trademarks back in episodes 68, 69, and 70, so I'd suggest going back to those episodes, or even episode 1, which I talked about intellectual property basics. In this episode, I'm going to talk about the factors used to determine whether your trademark is confusingly similar to another mark, and therefore you might get sued for infringement, or you might not get your trademark allowed by the United States Patent and Trademark Office. Now, these are important to know if your trademark gets rejected or if you get sued for trademark infringement, and you have to show that your trademark isn't confusingly similar to another person's mark, or if you want to sue someone else. You're going to want to know whether you're going to win by convincing a judge that the other company's mark is confusingly similar to yours. There are different tests used by different courts, but in the end, the outcome is probably going to be the same regardless of which set of factors you use. We're going to look at what the United States Patent and Trademark Office factors are and what they use. They use something called the DuPont Factors, and the name comes from a case in 1973, and there are 13 factors. The first factor is similarities of the marks in their appearance, sound, connotation, and commercial impression. So are the marks identical? If they are, that's a factor that will be considered really high for confusion. If they're really similar in how they look, or in, let's say, how they're spelled or how they sound, that's going to be a factor in determining likelihood of confusion. Let's say there's a streaming music company, and it's Pandora, and there's another company comes along and for streaming music, and they call themselves Pindora with an I. That's a pretty similar mark, and there might be confusion there. But what if the next company calls themselves Pindori? What about Binbora or Bindori? You can see that the farther away you get from Pandora, the less likelihood there will be confusion. So that's just a factor that courts are going to look at. The second factor is how related the products are between your competitor having a similar mark. Now, if one company does online music and the other does jewelry, those consumers probably wouldn't think it's the same company doing both. And once again, you could use Pandora as an example. There's a Pandora jewelry company and Pandora for streaming music. The goods and services are very different. So this factor plays well in arguing that you can have two marks that are actually identical, and there's not going to be any confusion about who's the origin of the source of those goods or services. Now, these first two marks are really the most important ones in determining a likely of confusion analysis. The third factor is similarities of established trade channels. Are they trading in the same way in place? If one person sells at a high-end jewelry store and the other person sells their products at the dollar store, those trade channels are pretty different. But if one person sells products at a high-end jewelry store and the other person sells products at a high-end purse store, well, those trade channels are a little bit more similar. So it's just another factor that the courts or patent office is going to look at. The fourth factor are the conditions under which sales are made. Is it an impulse buy, or is it careful consideration? Now, cars are not generally impulse buys. Usually you spend a lot of time trying to figure out what kind of car you're going to buy. So it's unlikely someone's going to confuse a brand name even if they're similar. Let's say Honda versus Hyundai. But if it's an impulse buy, if it's, let's say, candy bars, things that have similar names, more likely there could be some confusion because people aren't spending that much time trying to figure out, is this really the product I want, or did I want the other one with a very similar name? The fifth factor is fame of the prior mark. If you want to call your company McDonald's, even if you have nothing to do with selling hamburgers, McDonald's is so famous that you might not be allowed to do it. Now, these are just factors. Nothing is dispositive, but it's something to consider when trying to either sue someone for trademark infringement or trying to get your own mark. The sixth factor is the nature of similar marks on similar goods. Seventh factor is the presence of actual confusion. Do you have evidence that people were actually confused? Did you do a survey and find out that 10% of the people that were buying an item from one company or buying it from a competitor's company actually thought that they were buying it from your company? So that's another factor that plays in favor of likelihood of confusion. What if it's only 0.1% of people that got confused? Well, that doesn't weigh that heavily in favor of confusion, but it is something. It is not going to be weighed as much as if you had a survey that found, let's say, 25% of people were confused. The eighth is the length of time without actual confusion. If these different marks have been around for 20 years and you could show there hasn't been any confusion, that weighs in favor of no confusion. But if these products and marks have been around only 6 months, that might not be enough time to show that there is or will be confusion. The ninth factor are the variety of goods on which a mark is used. If the senior user has a lot of different goods where the mark is put on, that makes it stronger because people might assume that this new mark is this new product that has this mark is just another product from that same company instead of you trying to start your own company with a mark. The 10th factor is market interface between the marks being disputed. The 11th is the extent to which the trademark holder has a right to exclude others from using the mark. The 12th is the extent of potential confusion. And the 13th are what are called just other factors. So the patent office or courts can just use other factors. Now, all these factors are not going to be relevant in every single analysis. And the most important ones are the first two, the similarities of the marks and the similarity of the goods or services that these marks are used on or for. Now, as I mentioned, the tests I'm talking about, these are the DuPont factors. And personally, I think it's really too many factors to analyze for arriving at a likelihood of confusion analysis and result. There are other types of factors that different courts will use. There are the sleek craft factors for infringement, and there are 8 of them. That's used in the Ninth Circuit for trademark infringement. A lot of factors are the same as the DuPont, but some are different. There's another test called the Pignon factors, the First Circuit courts. The Second Circuit uses something called Polaroid factors. There's a lap factors in the Third Circuit, and there are 10 of them. And most of the courts use a test that has between 6 and 10 factors in the test. But honestly, the results probably aren't going to change that much regardless of which set of factors you're going to use because there's so much overlap. And in the end, you're really just trying to find out, are people going to be confused about these products or services being from the same company? Now, if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.